Hello there, and thank you for joining us in Trustees Week, where Scotland's Third Sector Governance Forum are running a number of events to support and inspire trustees in Scotland and celebrate all that you do. My name is Tracy Bird, and I run the SCVO Information Service, and I'm also a member of the Third Sector Governance Forum. The session today is being recorded, and the slides from all of the sessions this week will be on the Governance Forum website when Trustees Week is over. At the end of the week, participants will be asked for feedback and themes that you would like to see covered next year. There will also be a slide at the end of this session listing what else you can book up for, so do stay logged in to see that. Participants will be muted during our presentations, but I do encourage you to make suggestions, comments using the chat box as we go. So today our topic is trustees as employers, and there really is a lot to get right. To help us explore the issues, I'm delighted that we have with us Eleanor Mannion from MacRoberts Solicitors, who are one of the partners in SCVO's pro bono service, which offers free legal advice to SCVO members, and Lorna Robertson, who is going to tell you about SCVO's brand new HR and employment support service. Okay, I'm going to switch to my slides now. Okay, next slide. So today we're going to look at the role and responsibilities of trustees of voluntary organisations and charities when they have staff and what they need to know. Trustees are ultimately responsible for the safe and legal operation of their organisation. But what does that mean if you've got staff? Well, HR and employment law is the same for all employers, whether you're a charity or not. But if you're a trustee, there are the particular challenges of being a volunteer, often without any HR expertise to call on, and maybe only meeting up as a board 4 to 6 times a year. You're lucky if you have a board with an HR expert, but most people don't. So you need to ensure that your contracts and policies are fit for purpose and you know where to go if you need help. Because if you're faced with issues such as disciplinary or grievance procedures, loss of funding and potential redundancies, the challenge of remote working and supporting staff with mental health and well-being during this difficult time, then problems can escalate pretty quickly. And this can not only result in disharmony and financial cost, but can also potentially damage the reputation of your organisation and ultimately the sector as a whole. Next slide. So with Eleanor and Lorna's help, we're going to look at these fundamental issues today. We're going to look at the difference between governance and management, the importance of ensuring your contracts and policies are fit for purpose, trustees as employees, and if you do have that, the potential for conflicts of interest, and how the relationship between trustees and the senior team is crucial to success. Now, as I've said, if you've got any comments or questions, please put them in the chat box. We can't answer specific HR and employment queries today, but we will be able to tell you where you can access support through SCVO's new HR and employment support service. Okay, next slide. I'm going to start by looking at the importance of knowing the difference between governance and management. In my day-to-day work on SCVO's information service, I often have to help organisations where the trustees and the staff are in conflict, and that can weaken an organisation and lead to its ultimate failure. So knowing this difference is important. And it's so common an issue that it's addressed in one of the 5 core principles of the Scottish Governance Code for the third sector, and that's leadership. Next slide. So these are the 5 principles in the code. And if you want to find out more about the code, you can download a copy from the Third Sector Governance Forum website at goodgovernance.scot. So with leadership, on the next slide, the Governance Code focuses on the role of the board in providing strategic direction. And to do that, they have to understand their role and responsibilities. Because ultimately, if you're there to provide strategic direction, you can't get bogged down in the day-to-day organisational detail of your organisation. So you have to know and respect the difference between governance and management. So what is the difference? Next slide. Well, to summarise, Governance is about oversight and planning, overview of your organisation as a whole, long-term direction, and being ultimately accountable for actions and decisions. Management is about taking care of the daily operations, day-to-day projects. It's about short to medium-term implementation of plans, detailed planning, and being responsible for delivery. Of course, it's a delicate balancing act, hence the scales. And sometimes the lines between the roles can get blurred, and that's particularly in smaller organisations. So what can help in separating out the roles and responsibilities? Well, to get the balance right, so the board focuses on strategy, performance and assurance, rather than operational matters, it's vital as a trustee you know your role well and you understand the importance of boundaries. So you should have clear role descriptions for trustees, terms of reference for any subcommittees, and job descriptions for staff, and a scheme of delegation. And a scheme of delegation can help provide clarity around who's got the authority to make different decisions. And this should be regularly reviewed and available to all trustees, staff, and volunteers. So everyone is clear about their roles and responsibilities and legal liabilities. But remember, even if you delegate as a trustee, you're still ultimately responsible and accountable, both collectively and individually, for the work of your organisation. So that's it from me for the moment. I'm going to hand over to Eleanor, but while she's getting prepared, I'm just going to ask you to take part in a quick poll so we can find out where you access HR and employment support as a trustee. So there's a few choices here. Do you have an HR department? Maybe you're a larger organisation or HR staff. Do you have an HR expert on your board? Do you buy in support as and when you need it? Or maybe you use an HR or employment professional organisation. Or do you use a national body like ACAS or your local TSI? Or maybe you don't know where to go and you're really struggling. And if there is any other things there that I haven't put in the chat so that we can find out what people are actually using. So looking at this now, oh, that's quite surprising. A lot of you have got an HR expert on your board. You use HR employment professional. And there's one of you that doesn't know where to go and you're really struggling. So hopefully this webinar will help you out with that. So thanks for taking part in that. I really appreciate that insight to where you're at. And now I'm going to hand over to Eleanor. And as I say, she's from MacRoberts, one of our partners in SCVO's pro bono service. Over to you, Eleanor. Thank you.
Thanks very much, Tracy, and thanks very much for having me this afternoon. So, as Tracy mentioned, MacRoberts is part of SCVO's pro bono service, so we can provide some free legal advice if you come through that service. So what I'm going to talk to you about today is some of the employment law issues around you as trustees in terms of the organization, what you need to have in place. Okay. So what we are going to look at in the first instance is about employees. So what's the difference legally between an employee and a volunteer? Because I'm conscious that some of your organizations are going to have a mixture of both. Okay. So an employee is defined. It is defined in the legislation, the Employment Rights Act, and it's an individual who has entered into or works under a contract of employment. Now, that contract doesn't necessarily need to be a written contract, but as we'll move on, it is advisable that it is. But you can have written terms, and you can also have implied terms and some oral terms. So long as you have a contract of employment, that's your starting off point for an employee-employer relationship. As well as that, there are a couple of other things that employment law recognizes in terms of an employment relationship. So a level of control that the employer would have in terms of setting hours of work, rates of pay, holidays, things like that. All of those are control mechanisms. There's also what's called a mutuality of obligation, where there's an obligation on the employer to provide work and a mutual obligation on the employee to undertake that work. Okay, so those are the defining characteristics of an employee. A volunteer, on the other hand, is quite different, and there's no specific legal definition of what a volunteer is, but it's understood to be someone who's engaged in an activity, spending time unpaid to undertake something that is of benefit to a third party. Okay. There's been a good few cases actually that has gone to the Supreme Court on volunteers and whether they are classed as employees or workers and therefore get some employment rights. And in certain circumstances, those volunteers were found to have rights under the Equality Act, for example, but in very specific circumstances. So it's something that you want to get clear in terms of when you take on volunteers, in terms of the paperwork that you have, so that you have a difference between those who are employees and so have employment rights and those who are volunteers. Okay. So the next slide, please. We're going to talk about contracts of employment. Okay, so there are legal requirements in terms of what you need to set out in your employment contracts. So as I mentioned, you don't necessarily have to have a written contract, but you do need to provide what's called a statement of written particulars. And as of April this year, that must be provided to any new starts on day one. Okay, so it needs to be a single document that sets out various particulars in terms of their employment. Now, often that forms the contract of employment itself. And the things that are included in there are really quite straightforward and are set out on this slide here. And all the normal things that you would expect to be included in there: name of employer, the start date. Continuous employment is quite important as well. The job description or the job title. Remuneration is very important. So that's not just the scale or the rate of pay, but also any details in terms of calculating remuneration. So if there's overtime, if there are any standby or on-call payments, those things must be included. You also need to set out the intervals of payment. So is this going to be a weekly payment, monthly, etc.? And also any details in relation to the frequency of work, relating to hours of work. So if it's, an hourly rate of pay, that then it's also included that these are the hours that we expect you to work per week. And again, the days of work. Okay. Holidays is also very important to set out in your statement of particulars, and it's a legal requirement. So that includes the statutory minimum, if that's what you're going with, or the contractual holidays which are included for the employee. So it should set out what are annual leave days and what are public holidays, as well as any entitlement to accrued holiday pay on the termination of employment. It's also important to confirm whether any holidays can be carried over from a holiday year. The general provision is that holidays can't be carried over unless there are particular circumstances. So the fact that someone has been on maternity leave or other family-related leave, or if they have had long periods of sickness, which meant that they weren't able to use their holidays. There are also specific provisions brought in this year because of the COVID pandemic in relation to carrying over leave if people haven't been able to take their leave because of the effects of the pandemic. One of the changes that came in April this year was to include other benefits. So for example, if you have anything else over and above salary, any other expenses payments or any other benefit that's included, they need to be referred to in the statement of particulars. What is sometimes difficult for an employer is that they might have these benefits, like say, for example, an extra day off in December to prepare for Christmas, or a shorter working day on a Friday, some things that aren't contractual, but benefits that are provided to people. You have to now include them in your statement of particulars. But if you don't want them to have contractual effect, if you want that to be something that can be changed at a later date without having to go through the normal changes of terms and conditions situation, then you need to be very clear as to what benefits are contractual and what are not contractual. Okay. You also need to set out the provisions for the pension. So you need to include the pension scheme and the requirements for being involved in that. You need to let the employees know if there are any collective agreements that will apply to their employment, and also what training entitlement the employee can expect. So that's also the case. This was a new change again in April of this year. If there isn't any training apart from normal induction training that people undergo when they join any organization, that is fully set out in the statement of particulars as well. Now, the statement or the contract should outline the provisions under which that contract can come to an end. So how an employer can give notice and what notice requirements are provided in respect of the employee as well. So what length of notice will be applied. Now, you can have a statutory level of notice, and that basically is a week per year's service. So each year that is worked, another week of notice is provided, up to 12 weeks of notice. Alternatively, you can have something that says, you from day one, you're required to provide at least a month's notice if you resign, and the employer will also provide a month's notice. So that's something to bear in mind. But if your contractual notice is ever less than the statutory will prevail. So if your contracts state that everyone is to provide a month's notice, the employer or the employee, if that person then is working for you for 8 years, then despite that month, they will be entitled to 8 weeks notice. So that's just something to bear in mind. We tend to put in the statutory level as the fallback, so that everyone's clear on the level of notice required. What you also now need to include as well is whether a probationary period applies to the employment, and what that probationary period is, and the intention, which is usually to allow the employer to assess that person's suitability for the job. There's also a requirement to refer to disciplinary and grievance procedures, and I'll go into those procedures in a bit more detail later. But it is necessary to set out what the disciplinary rules are, and that's usually done by stating that there is a disciplinary and a grievance procedure, which are contained in not in the contract of employment, but maybe a handbook or on the intranet or something similar, and that will be used if there are any disciplinary matters, or if the employee wishes to raise any grievances. You also need to include in your statement of particulars that there is a right of appeal from the outcomes of both the disciplinary and grievance as well. Okay, so those are the minimum statutory requirements that you need to put into an employment contract. And it sounds like a lot, but to be honest, a lot of these are basic common sense things that you need to inform your employees about. But you also want to make sure that you are thinking at the very start, what is it that we need for this employee? What is their job title? What are we doing around holidays? What are we doing around pensions? How are we going to sort out if we need to let people go in terms of notice? How much notice are we giving? So it sets out the parameters of that at a very early stage. And then you can also have some organization specific terms in there as well that apply to you. So for example, if any of your people need to have a disclosure statement, or if you need to be registered with a regulatory body like the SSSC, or if you require a certain level of qualifications, or if you have other things that are going to be included there, such as like a car allowance or expenses, things like that. So that's all very clear from the very outset, what is contractual and what are those terms and conditions that will apply to the employees. Okay. Now we're going to move on and talk a little bit about arrangements for volunteers and whether volunteers should have agreements in place with the organization. And as I mentioned earlier, that there have been some cases where volunteers, particularly there have been a couple of cases against the Citizens Advice Bureau, where volunteers tried to make the case that they were employees. And one of the primary reasons that they would do so is that employees have full employment rights. So they are entitled to protection against discrimination, protection against unfair dismissal, redundancy rights, rights in relation to pay, rights in relation to holidays, etc. They have the full gauntlet of employment law rights, and volunteers don't. And I mean, the reason for that really is that it's not anticipated that a volunteer would have that kind of relationship with an organization. Instead, they're there usually to either fill a gap or to provide some particular type of assistance. If there's not specific funding for something, for some people, it might be about wanting to give back to a community or assisting in an area where they have specific experience. So for both the organization and the volunteer, it's not necessarily about building an employment relationship, but instead a way to give back. But what we would always set out is that the volunteers, and that's whether they are volunteers assisting with the staff or trustees as volunteers, that there is some level of agreement there, so that if there ever were to be a challenge, you can bring back and say, this is what we started off with. This is what we put in writing in terms of how this relationship would work. And the intention was not to create what we call legal relations or to create a binding agreement between the parties. You don't want to bring in too much formality. So we're not talking about the detail that you would have in an employment contract, but instead you want to have some guidelines around the relationship between volunteers and the organization. So what you don't want to do is take an employment contract and just copy that over, naming it a volunteer agreement. Because if you do so, a lot of those things in the employment contracts are suggesting mutuality of obligation, are suggesting a level of control by the organization, which are markers for employment. So by taking an employment contract and renaming it a volunteer agreement, you're running the risk that you are creating in law an employment relationship rather than a volunteer relationship. So what we normally suggest is that you do have a volunteer or a trustee agreement and that it's set out in a letter format, and it can be quite short, short and sweet. It should be non-legalistic and it should be informal in style. And essentially you want to phrase this in terms of the hopes and expectations as between the organization and the volunteer rather than obligations. Okay, so in terms of you as a trustee, a volunteer trustee, you know, it is hoped that you can provide a certain number of days throughout the year and to be available for a certain number of board meetings, that kind of thing. And for other volunteer staff, it would be around, we would like you to be able to contribute this much, to be part of this type of rota, but if that doesn't work for you, please let us know and we can make arrangements. So it's that hopes and expectations rather than obligations being set out. It can include things like the scope of the role, whether that person will be reporting into someone specific, any induction training they might need, and things like expenses, how the organization would manage that, as well as a request that the volunteer let the organization know in sufficient time if they will be stopping volunteering, so that the organization can put in place you know, a different rota or ensure that the work the volunteer was covering off is covered by someone else. What's also very, very important is to include an explicit statement in that volunteer or that trustee agreement that the organization does not intend the agreement to be legally binding and that there's no contractual intent between the parties. Okay, and so this is included so that you can be very clear if you end up in a challenge situation further down the line to go, this was our intention as the organization. We had no intention to create legal relations. Instead, we just wanted to provide some information as to how this relationship worked, but this isn't an employment situation. And so that will go quite far in terms of assisting you in defending any claim that you might have. Right, so we've looked at contracts and we've looked at what needs to be put in place there, and now we're going to talk a little bit about policies. I mean, when it comes to HR and employment policies, you can have as many as you want. Like there is a list, the length of my arm, of the types of policies that you can put in place. And depending on the type of organization, and usually the size of organization, really that's going to be the decider on how many you require. Okay. But I will say that there are some basics that you need to have in place. And as a minimum, you should have a disciplinary and a grievance policy. Now, I've referred to this when we talked about the employment contract. And what I will say is that all of these policies that I'm talking about are specific for employees. Okay, so these are employment policies only. So it's a statutory requirement to refer to a discipline and a grievance policy in that initial statement of particulars or contract of employment. And so you really do need to have then a policy to back that up. Okay. And depending on the size of the organization, they can be quite short and to the point. Or if you're a larger organization, you might require something a bit more detailed. Essentially, with the disciplinary policy, you should be providing examples of what the organization views as misconduct and gross misconduct, the steps the organization will follow when considering disciplinary matters, such as investigation, a disciplinary hearing, and an appeal stage, and the sanctions that can be applied. So going from an oral warning all the way up to dismissal. That way, an employee understands this is the standard of conduct that I'm going to be held to in terms of my employment, and this is the procedure that's going to be followed if I'm ever in a situation where a conduct issue arises. It also means for managers that they have something there which sets out the steps that they are required to take. And it also has some examples of the type of behavior or the type of conduct which will require them to take disciplinary action in respect of the employees. Now, grievance is slightly different. The grievance policies and procedures are to provide the employee with the right of a redress, essentially, to raise any concerns that they have and to ask the employer for a remedy. Okay, so it's about being open and transparent and allowing employees the opportunity to bring forward concerns that they have in relation to their employment. Now, again, that grievance policy should set out the matters that can be considered in the grievance procedure. And usually it's things like working relationship, maybe even workloads, maybe terms and conditions, but you want it to be separate from things like safeguarding. If that's going to be an issue, you probably want a safeguarding or a whistleblowing policy, which things should be dealt with like that. If you have something where it's, where the employee is bringing it forward as I'm not getting on with my manager, but actually it's something more detailed than that and more serious than that, and it's tipping into maybe bullying or something like that, then maybe that's not going to be best dealt with under the grievance procedure. Maybe that needs to be considered under the disciplinary procedure. So you want to set out what's going to be considered as a grievance and then the procedure that will follow. And usually that's an informal procedure initially. Can this be dealt with by an immediate line manager, or can this be dealt with at an informal level? And if not, then moving to a formal level. There may be some investigation, perhaps not, but there will be a grievance hearing, and then there also will be the right to appeal from that. So that as an employee, you can take up that policy and know what's going to happen if you have a grievance that you need to raise. As I've said, these two policies can be quite to the point. And what you really want to cover off is the rights and obligations in the ACAS Code of Practice. So the ACAS Code of Practice applies to all employment relationships, and it sets out the minimum requirements in terms of discipline and grievance. And those are the things that I've referred to today in terms of steps of procedures, etc. So it doesn't need to be an all singing, all dancing policy. It can be something quite short and sweet. The other one that I would say is an absolute necessity is a data protection policy and a privacy notice. This is because of the introduction of the GDPR Act in 2018 now. So we're 2 years on from day one of GDPR. So your data protection policy is going to set out the principles and the legal conditions that you must satisfy when obtaining, handling, processing, transporting, or storing personal data. Okay, so from an employment perspective, this is really important because from day one, as soon as you advertise for any role, you are going to be taking in personal data of both applicants and then, if anyone is appointed to those roles, of the employees. So how do you handle that data? How do you store it? What's going to happen to it? Who has access to it? And so it also sets out the rights the individual will have in relation to that personal data and how it's processed by the organization. It's also a very good idea, along with that data protection policy, is to have a privacy notice. So this sets out it deals with the requirement to notify data subjects about their personal data handling practices. Okay, so it sounds very technical, but really you're saying we as an organization hold data about you, employee. It's this type of data. This is how we are going to collect it, use it, store it, transfer it, etc. So it will apply to employees, workers, and contractors, but it can be adapted to reflect the staffing practices of the organization. So those two things are hand in hand in terms of the data protection piece, and are really, really crucial to have at the very outset. Often people, when you come on board or when an organization is starting off, they just kind of want to get going on things, but having this paperwork in place, it really sets out from the outset, where things are going, and gives that bank of everyone knows where they stand in terms of these things. And so you know what you need to do, and you also have information available for your employees, for your volunteers, etc., as to where you're going to be going next. A couple of other policies that I think are also really important to have is an equal opportunities policy. So a statement outlining your stance on discrimination and harassment. You might want to have an anti-harassment and bullying policy. So it would set out, the provisions that employees could raise concerns, or how harassment and bullying should be dealt with. It really goes hand in hand with the disciplinary and grievance piece, and I think it's very important to have this so that you as an organization are seen to take harassment and bullying seriously. Okay, because it will tie in with your obligations in terms of the Equality Act to protect those who have protected characteristics under the Equality Act. So that's pretty much what everyone has: age, sex, disability, race, sexual orientation, gender reassignment, pregnancy and maternity, marriage and civil partnership, religion and belief. So you want to make sure that those groups of people, which really covers everyone if you think about it, what the organization's stance is in terms of harassment. You might also want to have, depending on the organization, an anti-bribery and anti-corruption policy. It can be quite helpful, particularly if you're dealing with, say, public sector contracts or a lot of public sector work. And then other policies that's very important for organizations like yours to have a whistleblowing policy, because it encourages transparency in the workplace. It ensures that if there are safeguarding issues, people feel comfortable coming forward with these. And so that you have a procedure in place if there are concerns raised of the type that would be whistleblowing. And then some others like family-friendly policies. What do you do in terms of maternity leave or adoption leave or parental leave? What levels of pay will be paid, etc. Okay, so that's a kind of catch-all of the biggest and most important policies that I think organizations like yourselves should have. So we're going to move on now and talk a little about you as a trustee, and if potentially you are also an employee and where there's a conflict of interest there. And I think it's important to consider these two roles because, the role of a trustee, the role of an employee, it's not the same. They usually have a different legal basis, but you also have different objectives and different responsibilities. So as a trustee, you will have trustee duties, and they go beyond the obligations of the employment relationship. And if you think about it, to a certain degree, being an employee involves you coming to work, doing your job, and going home. But as a trustee, it's a lot more than that. As Tracy mentioned earlier, in terms of governance versus management, what you're thinking about is having a greater level of investment in the organization and a greater level of responsibility, and the need to keep that bigger picture in your mind at all times. So if you are undertaking both roles, if you are a trustee and you're also an employee organization, you need to consider what hat you're wearing at a particular point in time. Is there an intersection between the duties that you're undertaking as an employee and then the obligations that you have as a trustee? Because your trustee duties and those trustee responsibilities are something that you're going to have in the back of your mind at all times when you're wearing your employee hat. Okay. Equally, you may need to leave your employee role to the side at times when you are considering matters at trustee levels that will impact on employees as a whole across the organization. And it's no different really than being, a senior executive or a director in a private company where you're making decisions which will affect employees, but will affect you as an employee also. So as a trustee, your obligation there is always for the good of the organization rather than the personal impact that it will have on you as an employee. And so you always need to consider what's in the best interest of the organization rather than what's in the best interest for you as an employee. And be very mindful that the intersection of those two roles may lead to conflicts of interest. And if that's the case, to seek guidance perhaps from other trustees, if this is something that's quite new to you, to talk to your senior executives about that, but also to be aware that as you make those decisions as a trustee, what hat you're wearing, and ensure that at all times, again, it's always about the best interests of the organization and your obligations in terms of the charity law. So the next thing that I wanted to talk to you a little bit about is that relationship between trustees and senior executives. So as I referred to it when talking on the last slide, and as Tracy referred to earlier about this balance between your governance and your management. So, senior executives, their role essentially is to deal with that day-to-day management of the organization, to plan both short-term and long-term how the organization is going to succeed and how it is going to progress. And you as a trustee are there in some ways as a check and balance, and also to provide some additional assistance and expertise and to assist a charity to bring that charity forward and to assist the work of the senior executive. So what's really, really important is building a strong relationship with the senior executive team. And to ensure that the objectives and the outlook of both the senior executive team and the trustees is one and the same. And this can be quite important when you have serious issues in terms of maybe culture issues in the organization, in terms of the type of conduct that is condoned or permitted, or if you ever are in a very unfortunate situation where perhaps you need to deal with grievances against senior executives or even disciplinary matters in respect of senior executives. So as a trustee, you might become involved in disciplinary or grievance procedures if they involve senior persons within the organization. Because as I referred to when I talked about those, you might have investigation, discipline, and appeal stage. So if you have a senior executive who is being their conduct is being considered under the disciplinary proceedings, as a trustee, you might need to be brought in to assist. Maybe you're going to need to be the appeal here, or maybe you need to be the investigating officer, maybe you're going to be involved in the disciplinary procedures. So you want to have built up a good relationship with the senior executive team so that there is trust there in terms of taking that forward. And also so that you understand the role of the senior executives and the role of policies and procedures in terms of the organization as a whole, so that you can assist in any way that you can in bringing those forward. Okay, so what I'm going to talk about a little bit now was furlough and the job support scheme, the job retention scheme. And I had written this last Friday, or last week actually, and I have had to change it a number of times because the government has very kindly changed their mind since Wednesday last week to 2 hours ago as to what's happening with furlough and the job retention scheme and the job support scheme. So this is why this slide has been amended to not have a ton of detail in it, because I had to switch it out at the last minute. So you'll remember back when COVID all kicked off back in March and we were all put in lockdown number 1, on the announcement was made on the 20th of March. It was also announced that there would be furlough, there would be a coronavirus job retention scheme, which would allow employers to instruct their staff not to be at work. Those staff would continue to receive 80% of that pay. And up until about August, the government would pay that 80%. And then there was a moving of percentages so that the employer was then providing some top ups so that at all time the employee was receiving 80%, but that the employer was making some contributions to that too. So the coronavirus job retention scheme was supposed to end on Saturday, the 31st of October 2020. But that hasn't exactly happened because we now have a national lockdown in England. And you'll remember that First Minister Nicola Sturgeon made announcements last week about the various levels that Scotland is going to be at and where, in terms of the local authority, what level they're going to be at. And one of the difficulties with this is the fact that, and why it's changing so much, is that all employment law is a reserved matter. So any new legislation that comes out about employment law has to come out from Westminster. So the Scottish government and the First Minister can make various announcements about levels in terms of lockdown, etc. But when it comes to funding for things like the coronavirus job retention scheme, that needs to come from Westminster legislation and so Westminster decisions. So what we found out on Saturday was that there is going to be a national lockdown in England, and the coronavirus job retention scheme will be extended for 1 month to the end of November. What is not clear and what has changed a lot this morning is whether that money, that furlough money, will also be available to Scotland. Now, as a lawyer reviewing all the announcements and the guidance this morning, I was quite confident that it did. But the First Minister, over her lunchtime session, her press conference at lunch, said in her view that it didn't. So unfortunately, I don't have a definitive answer for you, but it may well be that if you are in a position where you are furloughing people, that you will be able to avail of the coronavirus job retention scheme for another month. And the reason why this is important is because there was also a job support scheme, which was introduced and which was supposed to start yesterday. And the job support scheme had 2 different areas. JSS Open, where employees were continuing to work, but working at there was a reduced requirement for them to be at work. And in terms of how much pay that they would be paid and how much the employer would pay and how much the government would pay. And there was also a feature of the JSS closed. So this was where an organization where employees would be unable to work because of a legal closure of the employer's premises. So again, there were provisions so that employees would receive a percentage of their pay. It was up to 67%, up to a maximum of £2,000 per month in that situation. However, because of all of the various announcements, in England at least, the job support scheme has been postponed until December. So that is what I can tell you about both of those schemes at the minute. But what I will say is that we are updating that constantly. And I know some of my colleagues in the background are drafting some articles and some guidance notes on that. So once we have those, what I'll do is I'll send them on to Tracy so that she can make them available for you. Because it's really unfortunate for employers and for organizations that we have these announcements and you guys are looking at your workforce going, right, what are we doing with them today? And how are we going to pay them this month? And what exactly applies? So as soon as we have some more information, I'll be able to give it to you. The other thing that you need to consider in terms of COVID, coronavirus, etc., with the lockdowns here in Scotland is the fact that we're going to have levels across the local authorities. So you might need to think about your staff, especially if maybe your organisation is in one local authority area and staff live in another, in terms of travel and things like that, if you still require people to be at work. If you don't require people to be at work, if people can work from home, how you are continuing to support them. One of the big problems we're seeing is kind of work from home fatigue a little bit at the minute, where, you know, how to support staff as the days are getting shorter and there's not really light at the end of the tunnel, perhaps. You know, it's a concern through the winter months already. It can feel a bit dark and dreary in Scotland. So how can you support your staff and make sure from a mental health perspective that they're okay? Because you've got a statutory duty in terms of health and safety. And that's fine when you're thinking about, right, you know, if they need to be in premises, what PPE do we have? You know, what kind of workflow we're going to have so that people are apart? How are we going to set out desks? But think about your statutory health and safety duty also in terms of people's mental health and people's welfare, and how you can support your staff through this really difficult, long period now that we've been going through. And a lot of that is really on the softer side of things. It's not really about having, you know, it's not about considering health and safety law. It's about considering, as an organization, how do we keep in touch with people? How do we make people feel included? How do we make people know that there is help available to them? And how can we have those conversations if we think people aren't doing particularly well? So those are some of the things that I just wanted to touch on today with everything that's happened. And now I'm going to pass back, I think, to Tracy. I hope.
Yes.
Yes,
Thank you.
lovely.
Lots to think about there. And who said it would be easy? Being a trustee or an employer or both. But no, that was a really good roundup, and do appreciate that. Thank you very much. There are a couple of questions. I think we've got a few minutes if I read them out to you.
Lovely.
So we've got from Richard, is the statement of particulars just another term for a contract of employment?
It is really, yeah. So the statement of particulars is the most basic. It's usually like name of employer, name of employee, and it goes down like that. Whereas the contract of employment often include, and so the statement of particulars would just be the bare minimum requirements that I included on that slide. Whereas the contract often includes other additional terms and conditions and has a bit more detail around there. So you can have either, but you need to have those basic requirements in one single document. So what used to be was that you would get maybe a letter of appointment or a statement of particulars that would include some things, and then other provisions would be in the contract. Now they all need to be in the one place.
All right, great. And does an employee, if resigning, need to give 1 week notice per year of service if the contract states less?
No. So the statutory is, it is a week per year starting from 2 years. So if they have less than 1 year's service, then you can set, you know, the amount of notice for that, whether it's a day or a couple of days. But you want to make sure that if you're coming close to the 12 months or to 2 years, that you are giving sufficient notice so that including the notice period, they get the, you know, they if, for example, their notice period would bring them over a year or 2 years, that they're getting the right amount of notice. Okay.
And I've got one from May Millward, who I know myself. They do a lot of work with us on mediation, Scottish mediation, and they're asking, they're often approached when a complaint or grievance has been raised against a board member, and very often the actions that the board have taken in response have aggravated the issue. Know that one only too well. And made the situation worse. Is there a template for how these issues should be handled? And is it different if the issue is raised by an employee or by a volunteer? Should it mirror the employee grievance procedure? So there's a lot to unpack in that one.
So yes, there is going to be a difference with how this is dealt with if it's an employee or a volunteer. So the ACAS code of practice that I referred to, bare minimum, that the best practice that you need for your disciplinary and grievance, that only applies to employees. So you can have a mechanism that allows volunteers to raise concerns or to raise grievances, essentially, but it shouldn't be as detailed as the employment one, because you want to have a split between who's an employee and the protections that are offered. But also, as volunteers, you want to have that open transparency. You want to know if there are issues in an organization and issues with board members, etc. Okay, so yes, you could have like a shortened version of that allows a volunteer to also raise concerns and to raise grievances, essentially. Okay, it's difficult when these are against board members. And what I talked about having levels so that you have enough people to act in the various situations. So an investigator, a disciplinary officer, an appeal officer, if this is a discipline issue. But if it's a grievance issue that might switch over into discipline later, then you need to consider that as well. So that's why the trustees often get involved. And I think a lot of the time it's about training, so that people understand their roles, so that board members understand their roles in terms of, yes, you're running this organization, but also you have obligations, you've got responsibilities in terms of staff and volunteers. So how that relationship needs to work, and how, as a charitable organization, the type of culture that you want to have, so that you don't have board members, kind of jumping in and making things a lot worse when people are raising genuine issues or genuine grievances and are saying, look, as an organization, we think you shouldn't be doing X, Y, and Z. That's not personal against a board member, but sometimes they can take it personally. They need to be open to criticism, because in the third sector, what you want to encourage and what you want to have is this open, transparent communication between everyone within an organization to ensure that you're getting to that stage where anyone can raise a concern and that it will be dealt with properly, but that you're not stymieing talk and discussion and communication within an organization. So I hope that helps.
Difficult to get that balance sometimes.
Yeah.
They're coming in thick and fast, so we'll try and do as many as we can, but we do have the HR service, so some of them might need to go to that. But I've got one from Laura Downs, and she's asking, is it acceptable to apply the employee disciplinary and grievance policies to volunteers so that we treat them in a fair and open manner?
I would say no. So, I mean, really, you shouldn't be, when we're talking about discipline, what you're talking about is the standards of conduct you want in your organization, but also it's a mechanism that allows you to legally dismiss someone. So gross misconduct is a legal reason to dismiss an employee. Whereas with a volunteer, if something happens and you're not necessarily happy with what they're doing, you don't need to go through the rigmarole of a whole detailed procedure to say to a volunteer, this isn't working, we're not happy with X, Y, and Z, we'd like you to leave. Depending on the seriousness of that concern, you might want to do some investigation, you might want to have documentation, especially if it's a safeguarding issue, if it involves finances, or if it involves vulnerable people, or if it involves general cultural bullying, harassment issues. You might want to look into that, but I wouldn't be applying the detailed disciplinary proceedings to volunteers, because it suggests a level of protection that they don't have, and that, I mean, you don't really want to be giving, because once you do that, then you open the door to every employment right, including national minimum wage, paid annual leave, right to a redundancy payment, etc. So yes, you want to do right by your volunteers and have them as part of your organization, and really, their work is really fundamental and really helpful, but you need to be clear legally of the difference between volunteers and employees, and the roles and the roles that they have within that organization.
Okay, yeah. You mentioned the need to include benefits in a contract of employment. So would that include flexible working arrangements?
It can do. It can do, yes. So this was a new thing that was brought in April. We usually get new employment law in April and October of each year. October this year has been a no-go for new employment law. But yes, so benefits now need to be included in that statement of particulars or in that employment contract. So if you provide for flexible working, it can be as basic as this organization also allows for flexible working, and we would refer you to our flexible working policy, which can be found blah. There is no contractual right to flexible working. Okay, so it's as basic as that, as going through the list of things that you have and going, right, what do we need to include? And really it's more about listing so that people are aware of these things, because there's always a concern if you've got a very detailed handbook that people aren't actually going through it to see what they're entitled to.
Yeah. Okay, and the last one, because we're running out of time and we need to go to Lorna soon. How frequently should contracts of employment be reviewed for long-standing members of staff? How often?
Okay, so I guess when we're talking about reviewing, it's what do you want to do with the review? So with GDPR, we all needed to review contracts of employment because if there were data protection provisions in there, then we needed to update those so that they were relevant to the law. And with those new Section 1 requirements that came in April, we were saying to people, review your contracts of employment, make sure that all these things are now covered off. But essentially, if you are changing terms and conditions, if you are reviewing a contract and going, right, we're paying this overtime, we can't afford to do that anymore, or we want to make people more flexible in terms of their hours. So instead of working 9 to 5, Monday to Friday, we want a lot more flexibility. You then need to enter into a process that would allow you to change those terms and conditions. Once the terms and conditions are set out, they're set. And they can't be changed without the agreement of the employee, or if you're going to impose them, so that you as an organization understand the risk of imposing changes to terms and conditions. Because what you're essentially doing then is ending that first contract of employment, starting a new contract of employment, and in law, that's technically a dismissal. So yes, you can review your contracts even annually every 2 years. I'd be suggesting from a policy perspective, you're reviewing those every year. But with your contracts, if you're reviewing them, I would be questioning what the purpose of that review is for, because it then will lead to, if you want to make changes, how you go about those. Any fundamental changes is ultimately ending that contract and has lots of legal implications for the employment relationship.
Okay, thank you. I think we've all agreed there's nothing as a straightforward question, but
no. And unfortunately, a lot of my answers are, well, it depends. But yes,
no, and it does, though, doesn't it? Yeah. No, I really appreciate your time, Eleanor. Thank you very much for all that information.
You're most welcome, and thanks for having me. It's always a joy to be with SCView.
Oh, that's brilliant. Thank you. Okay, I'm just going to do another quick poll and then I'll hand over to Lorna to tell you about our new HR service. I'm now just really wanting to know what's the areas of HR employment law that you want to receive more support with. So we've got their contracts, policies and procedures, you know, the real basic stuff. Or is it the government support schemes that Eleanor talked about? Is it blended and remote working? We're all having to get used to that. Or maybe redundancy and restructuring, or supporting mental health and well-being, discipline, grievance, absence management. And we do have another choice that you could put in the chat, but just very quickly. So yeah, contracts, policies and procedures. So it's that real fundamental stuff. And that's very interesting, supporting mental health and well-being. And that's not surprising, I don't think, at the moment either. Okay, well, thank you for taking part in that. I'm going to hand over now to Lorna, and she will tell you a little bit about our brand new HR and employment support service, which we've just launched. And you can take all your difficult questions to Lorna after this webinar. And when we end, I'm going to leave up a slide with details of other free events for the week that I'd encourage you to sign up to. But I'll hand over to Lorna now. Thank you.
Thanks, Tracy. Hi everyone, my name's Lorna. I am SCVO's HR and Employment Support Service Officer. I started in the role 3 weeks ago, and in that time we've been really busy getting everything ready to launch our new service. As this webinar has an HR theme, I wanted to give you a bit more information about how our service will work. It came about after recognising that there was a demand within the sector for a dedicated first-tier support service for HR queries. After we launched our Coronavirus Information Hub, we saw that the second most searched topic after funding was HR. So how will it work? Initially, when an organisation has a question relating to HR, so that could be about wellbeing, policies, procedures, recruitment, redundancy, or more COVID-19 specific queries like paying employees when they're isolating, there's a web form available on our website, which just went live today, which can be completed and sent over to us. The form includes space to summarise the query, which is then sent through to our HR team. At this point, we would triage the query and decide if we can deal with it via email or set up a one-to-one call of up to 30 minutes. Everything up to this point is free to organisations, whether you are a member of SCVO or not. If more complex queries come through that require a more specialised and longer discussion, we'd set up a pro bono partner referral. At this stage, we would require organisations to be a member of SCVO, and the costs for this are incremental depending on annual turnover. So it's free if annual turnover is £50,000 or less. It's important to note that this is a first tier support service, so we won't be offering legal advice or services in terms of creating or updating policies or handbooks, etc. We will offer support and guidance with queries and signpost to the appropriate place if requested or required. As well as the one-to-one service and web form, we're also working on an HR information hub on our website. Initially, this is going to display vital HR information in relation to COVID-19, so mental health and well-being, remote working, supporting colleagues who can't work due to the virus in any capacity, and information should the need to consider redundancies arise. This is currently being developed and more information will be available on the website soon, and is being designed with the third sector in mind. Over time, we'll expand on this to introduce any and all HR topics to the Information Hub, and we'll also monitor the queries for any trends or capability needs that arise across the sector. We would at that point be looking to host webinars and events, much like this one, to cover the knowledge needed at that one point in time. That's the service in a nutshell, really, and the only thing left for me to say is that our service is now live and open for queries. So if anything has come up for you today, you can fill in the web form and ask a question should you wish. And thank you very much for listening. Back to you, Tracy.
Thanks, Lorna. I think you're going to be busy. And thank you all for joining us today. Really appreciate you giving us your time, and I hope you found it useful. And we're just going to finish off with that slide. If you want to sign up for more sessions this week, you go to the Governance Forum website. And thank you and have a good week. Goodbye.